In 2020, a 22-year-old singer from Kano sent a voice note in a WhatsApp group. He was praising a Sufi cleric he admired. Other members in the group disagreed with what he said. They reported him. Within weeks, he was arrested. Within months, he was tried. And a court in Nigeria, on Nigerian soil, under Nigerian jurisdiction, sentenced him to death. Not for terrorism, not for murder, not for armed robbery, for a WhatsApp message. His name is Yahaya Sharif-Aminu, and his case is not the exception. It is the system working exactly as designed. Today we are going inside Nigeria's Sharia courts, how they were built, what they have done, who they answer to, and what they are preparing to do next. Because if you believe this only affects the north of Nigeria, you have not been paying attention, and by the end of this video, you will understand why. Most channels cover the headline. This channel covers the architecture behind it. If you are watching for the first time, you just found Nigeria's most analytical political channel. Subscribe, because what comes next in this video is the part most commentators are too cautious to say out loud.
What most Nigerians have never fully confronted. Nigeria runs 3 parallel legal systems simultaneously. The common law system, inherited from the British, operates across the country for civil and criminal matters. Customary law, community-based rules, governs land disputes and inheritance in certain localities. And then there is Sharia law. Not Sharia as a private religious practice, Sharia as a fully functioning criminal justice system, complete with its own police, its own courts, its own prisons, and its own sentences, including amputation and death by stoning, operating across 12 northern states of the Federal Republic of Nigeria. 12 states, with active jurisdiction over millions of Nigerian citizens. All of this within a country whose 1999 Constitution, Section 10, explicitly states, "The government of the Federation or of a state shall not adopt any religion as state religion." That is the text. That is Section 10. That is the supreme law of the Federal Republic. And 12 states are in open, sustained, documented violation of it. The legal mechanism the 12 states use to justify this constitutional contradiction, and why the federal government has never challenged it in the Supreme Court in 26 years of democratic governance, is one of the most revealing stories in modern Nigerian political history. We will come to it. There is currently active legislative advocacy in several northern states to extend Sharia jurisdiction beyond Muslim citizens. We will address exactly what that means and what it would require.
The year was 1999. Nigeria had just emerged from 16 years of military rule. Presidential elections were held, gubernatorial elections followed, and in the excitement and fragility of that democratic opening, something else was happening in the north that most southern commentators missed entirely. Ambitious politicians running for governorships in the northern states discovered that Sharia was the most effective political promise available. It carried moral authority, cultural resonance, and crucially, an almost unassailable position. Who campaigns against God's law? Zamfara State Governor Ahmad Sani Yerima moved first. In January 2000, Zamfara formally adopted full Sharia criminal law, the first state in democratic Nigeria to do so. The reaction across the north was immediate, not opposition, imitation. 11 other states followed within 24 months: Sokoto, Kebbi, Niger, Kano, Katsina, Bauchi, Borno, Yobe, Jigawa, Kaduna, Gombe. 12 states, full Sharia criminal jurisdiction in under 2 years. Obasanjo's calculation and its consequences. President Olusegun Obasanjo made a decision at this moment that defines everything that followed. He did not challenge the Sharia adoptions in the Supreme Court. He did not invoke federal constitutional authority. He managed it quietly, carefully, with the logic of a man who understood that directly confronting Sharia in 2000 would cost him the entire northern political bloc he needed to govern. Every president since Obasanjo has made the same calculation. Yar'Adua, Jonathan, Buhari, Tinubu, each one has held the constitutional challenge in reserve, deciding it is not the right moment, and so the 26-year clock runs. The precedent established in 2000 was not just legal, it was political. It told northern state governments that the federal constitution is selectively enforceable, that sufficiently popular constitutional violations will not be challenged. That precedent has never been reversed. The governors who did this were not primarily religious. Ahmad Sani Yerima, the man who launched the Sharia expansion in Zamfara, was later elected to the Senate, where he was accused by his own colleagues of marrying a 13-year-old Egyptian girl in violation of Nigerian child protection law. The man who built the first modern Sharia criminal jurisdiction in Nigeria was subsequently the subject of a child marriage scandal in the Nigerian Senate. His defenders cited Sharia law as justification. This is the political DNA of the institution. Keep that in mind as we proceed. The architecture of Sharia criminal jurisdiction. Sharia courts in the 12 states operate on a tiered structure. Lower Sharia courts handle minor civil and criminal matters. Upper Sharia courts handle serious criminal cases. Sharia courts of appeal review decisions from below. The criminal sentences prescribed under the hudud, the fixed punishments in classical Sharia jurisprudence, include flogging for alcohol consumption, amputation of the right hand for theft, and death by stoning or hanging for offenses including adultery, apostasy, and blasphemy. These are not theoretical provisions on paper. They have been sentenced. Some have been carried out. The sentences that made international headlines. In 2001, Safia Hussaini, a divorced mother in Sokoto State, was sentenced to death by stoning for adultery. International pressure and legal appeals led to her acquittal. In 2002, Amina Lawal in Katsina received an identical sentence. International advocacy again produced an acquittal on appeal. In 2020, a man in Kano State was sentenced to death for blasphemy over a WhatsApp message. We will come to his case in full. In the same year, a 13-year-old boy in Sokoto was sentenced to 10 years in prison and 24 strokes of the cane for a blasphemous remark made in an argument. Here is what the Safia and Amina cases obscure. The international pressure that reversed those verdicts did not reform the system. It did not eliminate the courts. It did not challenge the legal architecture. It produced individual reversals while leaving the institution that generated them completely intact. 23 years after Amina's acquittal, the same court system sentenced a 22-year-old to death for a voice note. Systemic severity. These are not aberrations produced by rogue judges. They are the predictable output of a legal architecture that has never been fundamentally challenged. Who he is. Yahaya Sharif-Aminu was born in Kano. He was a singer of Tijaniya devotional music, a Sufi Islamic tradition with deep roots across West Africa, practiced by millions of Nigerian Muslims. In March 2020, as COVID-19 was spreading and Nigeria's attention was elsewhere, he sent a voice note in a WhatsApp group. In it, he praised the founder of the Tijaniya order, suggesting this Sufi cleric occupied a spiritual rank comparable to or higher than the Prophet Muhammad. Within Tijaniya theology, this is a debated position. Muslims have argued questions of spiritual hierarchy for centuries. This is not fringe theology, it is internal religious discourse. What happened next? Several members of the WhatsApp group took serious offense. They reported him to the Kano State Sharia court. Protesters gathered outside his family's home. They burned the house down. Yahaya was arrested. He was brought before the Kano State Upper Sharia Court. Initially, he had no legal representation. He was charged under the Kano State Sharia Penal Code Law of 2000, specifically the blasphemy provisions. On 10 August 2020, he was convicted. The sentence handed down, death by hanging. He was 22 years old. He was convicted for a voice note in a WhatsApp group in Nigeria. The international response and what it did not do. Amnesty International issued condemnation. The United Nations raised the case. Western governments expressed concern. In 2021, a Kano High Court ordered a retrial on procedural grounds, not on the merits of the constitutional question, not on whether blasphemy law can lawfully exist in a secular Nigerian state, but on procedural grounds. As of this video, Yahaya Sharif-Aminu's charge has not been dropped. The Kano Sharia Penal Code provision under which he was convicted has not been repealed. The court that sentenced him to death continues to operate. He is not free. He is waiting. Case status. A Nigerian citizen has been under active threat of execution for a WhatsApp message for over 5 years. The federal government has not intervened constitutionally. If you believe Yahaya's case is exceptional, the record corrects you. Omar Farouq, age 13. In August 2020, a Sharia court in Sokoto State sentenced a 13-year-old boy named Omar Farouq to 10 years in prison and 24 strokes of the cane. His crime was making a blasphemous statement during an argument with a friend. He was 13 years old, 24 lashes, 10 years imprisonment from a Nigerian court in 2020. Mubarak Bala is the president of the Humanist Association of Nigeria. In April 2020, he was arrested in Kaduna State following complaints about his Facebook posts critical of Islam and religion broadly. He was held without trial for 2 years, not 2 weeks, not 2 months, 2 years without charge. In 2022, he entered a plea bargain agreement after enduring that pre-trial detention and was sentenced to 24 years in prison. 24 years for Facebook posts. His case was documented by Amnesty International, PEN International, and multiple international press freedom organizations. The documentation did not accelerate his release. He served time. The pattern in all 3 cases, Yahaya, Omar Farouq, Mubarak Bala. Every single prosecution follows the same architecture. A statement is made in a digital space, WhatsApp, a conversation, Facebook. A third party reports it to the state. The state acts. The federal government does not intervene. International pressure produces individual case management, not systemic reform. The next prosecution proceeds on the identical legal basis as the last. The system learns nothing because there is no institutional pressure requiring it to learn anything. The legal architecture. We said we would return to how 12 states justify running full criminal courts in a constitutionally secular federation. Here is the answer. Section 277 of the 1999 Constitution grants state governments authority to establish Sharia courts for personal law matters, meaning civil disputes between consenting Muslim parties around family law, inheritance, and related issues. Personal law, civil disputes between consenting parties. The 12 states took a provision designed for civil family matters and expanded it to cover criminal jurisdiction, capital punishment, and the prosecution of non-consensual religious expression. There is no constitutional basis for this expansion. There has never been a Supreme Court ruling confirming it. It has simply never been challenged. Every attorney general, every president, every federal legislature since 1999, all of them have declined to take this to the Supreme Court for a definitive ruling. Section 10 prohibits state religion. Section 38 guarantees freedom of conscience. Neither has been applied to invalidate Sharia criminal jurisdiction. The mechanism for applying them, a Supreme Court referral, has not been used in 26 years. The expansion agenda. There are documented calls from within northern state legislatures and some civil society structures to extend Sharia jurisdiction to non-Muslim Nigerians on matters affecting Muslim interests, including property disputes, commercial contracts, and public conduct in Sharia states. These are not fringe positions. They have been raised by sitting legislators. The constitutional barrier to this expansion is the same Section 10 and Section 38 that have not been enforced for 26 years. An unenforced constitutional provision is not a barrier. It is an invitation. I want to speak directly to those of you watching from Lagos, from Enugu, from Port Harcourt, from Ibadan, from Benin City, who may have watched this video thinking this is a northern problem. It does not affect me. You are wrong. And here is the precise reason why. First, the constitutional precedent set by 26 years of federal silence does not stay in the north. If state governments can openly operate in violation of Section 10 and Section 38 without federal challenge, you have established that the Constitution is selectively enforced based on political calculation. That principle has no geographic boundary. Second, hundreds of thousands of Nigerian Christians, atheists, traditional religion practitioners, and minority sect Muslims live within the 12 Sharia states. They are Nigerian citizens. Their rights are subordinated daily within a constitutional framework that has never been enforced on their behalf. Third, Nigeria's international reputation, its treaty obligations, and its stated commitments to the African Charter on Human and People's Rights are all contradicted by a legal system that sentences a 22-year-old for a voice note. Every time a Nigerian diplomat sits at an international table and speaks about rule of law and democracy, Yahaya Sharif-Aminu's case is the counter-evidence. The silence of southern politicians and civil society organizations on Sharia court jurisdiction is not political neutrality. It is calculated avoidance, and calculated avoidance is indistinguishable from complicity. Yahaya Sharif-Aminu is still alive as of this video. He is still in Nigeria. He is still within a legal system that sentenced him to death for a voice note. He was 22 years old when that sentence was handed down. He sent a WhatsApp message, and a Nigerian court operating inside the borders of the giant of Africa told him he should die for it. The gap between what Nigeria claims to be and what Nigeria demonstrably is, that gap is measured in cases like Yahaya's. If this video showed you something you did not know, or showed you something you knew but had not yet said out loud, do one thing: share it. Not because this channel needs the numbers, because this story deserves to be seen by every Nigerian who has the right to know what is being done inside this country's borders in this country's name. If you are new to this channel, subscribe. We do not do headlines, we do architecture.